Okay, we will start. Good morning. Good morning, everyone. Day two of the conference. For those of you who didn't join us yesterday, so we continue with the theme of regulatory uncertainty. I feel like over the past years we are in this crisis mode. So the name it crisis, emergencies, etc. Today, the first panel is going to focus on what I would call more how we think about markets and relationships between market states and society. But basically, the theme is EU competition law and more broadly, some of the speakers I'm going to introduce in a moment are going to talk about more digital markets, digital economy, and how we imagine and what is the kind of economy and society we want to live in. My name is Kati, Cseres. I work here at the Department of International and European Law, and I have an excellent panel this morning. So let me introduce them now in the order of speaking, because you are already standing up. Chase Foster from King's College London, a lecturer in politics, and his research is on comparative international political economy. So I'm very much looking forward to your presentation. Then we will hear Anna Gerbrandy, who is a professor of competition law at the University of Utrecht, but also beyond your title, somebody said that a hero in our competition community, and especially for female scorers as students, I very much recommend that you follow her work. Then we have Cecilia Rikap, who is an economist, so we also have a nice balance in disciplines. Associate professor at UCL, University College of London, and we will hear, I think, from you about digital sovereignty and how to reimagine this space pressure. And then we are very welcome to Sébastien Pant, who is from, and I don't pronounce it correctly because the French, I always just say BEUC, the European level of consumer protection agency, who is also all national consumer, no, not agencies, authorities. So you are the one at the EU level who stands up for the rights and interests of consumers, and Sébastien is a senior officer at this organization dealing specifically with competition in the digital environment. So the format is as yesterday. Each speaker will have about 12 minutes, and then I am very happy to immediately open up the floor for questions, or we will see whether they would have questions for each other, as I also probably will have questions, and we will have a discussion at the end. So, Chase, yeah, you took the floor, so please go ahead.
Okay. So I'm Chase Foster. I work in the Department of European International Studies at King's College London, and I'm a political scientist who works on economic law. And so I have, let's say, a different approach than at least many of the lawyers and economists who I've encountered, though this group of lawyers and encounters I've encountered is much more open, I think, to political science approaches. So that's been really nice to hear and see. And this is a new project, so I'm really looking for feedback about how we can improve the conceptualization, measurement, and analysis. I've been working on various projects related to regulatory law and in particular competition law over the past decade or so. And a lot of that work has been focused on the relationship between capitalism and the development of competition law. This kind of comes out of that first book project, which I'm trying to finish, right? Because I needed to conclude and I wanted to account for what's happening now, and I realized I didn't have a framework for it. Okay, so this is kind of growing out of that project, and it's new, but it does kind of build on earlier work that I've done. Okay, so this is called the Repoliticization of Antitrust, Regulatory Continuity and Change in a Populist Age. So I guess the starting premise is that antitrust has been understood as a depoliticized area of policy. I realize that might be a loaded term, right, especially for lawyers. But what I mean by that is a public policy arena that is not particularly politically salient, right, among publics and in legislatures. It's not something that's deeply It wasn't deeply politically contested. It wasn't a major focus of electoral campaigns, et cetera. And the politics of antitrust were dominated mostly by affected interests and economists and lawyers who were part of well-established epistemic communities, right? And maybe there are some geopolitical implications from time to time, but this was not, let's say, a central political issue in most of the polities I've looked at. And that contrasts very much from the late 19th century when antitrust was arguably the most important issue in some places, right? I mean, in the 1912 US presidential election, there were 3 presidential candidates. They each had distinct understandings of antitrust, and this really was what motivated a lot of their economic policy. The question is, are we returning to that kind of moment, right? Are we seeing the repoliticization of competition law and policy? And just as kind of motivational anecdotes, we certainly have seen much more discussion of antitrust, monopoly power, market power in the US Congress, as well as many other legislatures, as I'm going to show you in a second. And we also are now seeing even the contestation of the European Union's competition law at a level that I haven't observed, at least from my prior research. And so what I'm going to first do is kind of provide some empirical evidence, some initial attempts to provide empirical evidence that this issue is becoming more salient over time in both the US and the EU, using political party manifestos, right, and systematic analysis of party manifesto data. And then I'm going to use some qualitative analysis, again, very tentative and early stage, try to see if this rise in political salience appears to be linked, not saying causal, but some kind of correlation with observed changes in policy priorities and enforcement actions in both the US and the EU. And then my tentative conclusion is that there does seem to be some shift in investigations and enforcement that does appear tied to politicization, but it's unclear exactly what this is going to do, right? Will this be short-term? Will it be long-term? Will these new kinds of cases be accepted by courts? Are we actually going to see a fundamental transformation of competition law in practice? That is, I think, too soon to tell. Okay, so just to kind of put out some definitions, I'm drawing mostly from Pepper Culpepper's understanding of political salience and other political scientists' understanding of political salience as the importance assigned to a policy issue by parties, media, and the public. So I'm not thinking about politicization the way some of us discussed it yesterday, which was a broader understanding of, bringing politics in through consultation processes or adjusting policy because of the way it affects stakeholders. I'm really thinking about mass publics and popular contestation, right? Through legislatures, through the media, and through popular political mobilization. And Culpepper argues that a lot of policy areas go through periods of high salience and low salience. High salience when the issue gains prominence in the media because of a scandal, right? Or it's kind of brought into the political sphere by entrepreneurial politicians. Public opinion often polarizes. That leads more actors and audiences to engage, but that over time, that salience tends to go down, right? And the policy area turns to something more like low salience, right? Where the debate is concentrated mostly among technocrats and lobbyists. And so in order to see if we can observe a shift in salience over time, I've been working with Sébastien to examine party manifesto data since the 19th century across more than 20 countries, and he's done most of this work, so I should give him credit for the machine learning and all this stuff. But essentially, we're using different ways to try to measure the salience of antitrust issues and market power concerns in party manifesto data over the long term. Okay, we've also done some hand coding just to make sure what we're observing is is real, right? And so these are our initial findings. It's kind of hard to read, but essentially the graph on your left, that is, okay, I'll start here. The graph on the right, this is just from the Comparative Manifesto Project. Okay, so this was coded by someone else, right? And there is a market regulation index that covers competition law, but also concerns consumer issues. Okay. And this is essentially the percent of quasi-sentences where market regulation comes up in a party manifesto. And what we have seen is, according to the Comparative Manifesto Project's coding, we have seen an increase in market regulation, right, in the role of party manifestos across countries, and actually on the left and the right. Okay. The machine learning basically extends the principles seen from the Comparative Manifesto Project to earlier manifestos using the raw data. Those were not coded by the comparator. There we see something kind of like a cycle down in the 70s, 80s, and 90s, and a return to salience around 2005, 2010. Sébastien and I have also developed an original competition law dictionary, which allows us to more precisely identify competition law concerns within manifestos. And here I'm just showing results for Germany and the United States. It is interesting that in Germany, there's been a clear increase, right? This is the percent of manifestos that have at least one dictionary mention of either consumer welfare, fair competition, or monopoly. And there we can see that parties on the left and the right have seen a clear upward tick in salience. The United States is more mixed. The fair competition issue does not seem to be something that is discussed much in recent years, but it was discussed in previous periods. So this is just to give you a sense of maybe what we're thinking. We're also going to maybe look at median dates of the measures. Okay, now I'm going to just provide some initial evidence from the case studies. So this is the quick story of the United States. I need to move quickly. So essentially, we see an effort to enact new anti-monopoly laws, right? New regulations to try to address the problem of big tech. All of them have failed. Okay, we've had a lot of debate. Not a single one has been enacted. It appears that tech giants spent a lot of money lobbying and campaigning, and fear of big donor backlash kept the bills off of the floor. At the same time, we have seen a significant increase in enforcement and a shift in some of the kinds of cases that are now pursued in the United States, right? Everyone knows about Nina Khan, and as well as the Assistant Attorney General, Cantor. It's Eric Cantor, right? Jonathan Cantor, sorry. Jonathan Cantor. And we clearly have seen more anti-monopoly lawsuits under Section 2. We've seen a more aggressive approach to merger enforcement that includes a variety of non-horizontal cases. We've seen more ex-ante rulemaking. And even under this administration, a lot of this has continued, right? Surprisingly, there is maybe some shifts so far, and maybe we don't know what will really happen, but there's been a shift in enforcement. What seems to be preventing a wholesale shift in the United States is the courts, right? The courts have struck down a lot of the new labor market cases. They've blocked many of the more, let's say, unconventional merger cases. There have been some limited successes, but there's been a lot of losses. And then recently we saw the FTC case get struck down, and we saw even these partial victories against Google really had pretty narrow remedies that did not appear to fundamentally change any of these markets. In fact, Google stock has been continuing to go up. And if we look at this US Supreme Court, or even the Google case will be appealed eventually probably, we see that the court has more or less ruled against anti-monopoly lawsuits and in favor of a law and economics position since the early 2000s. And it doesn't seem like the court has necessarily changed. If anything's become more conservative, we'll see. Everything's up for grabs now. But I would project that there will not, at least in the short term, be a significant change in many of the core areas of antitrust. The EU, we also have seen a flurry of legislation that all of us know about. I'm not going to summarize all these things because I don't have time, but we certainly have, let's say, not only a kind of more intensive focus on enforcing cases against big tech, but we now have legislation to strengthen the tools that the European Commission and national regulators have to address these issues. There also is new contestation of merger policy, especially since the European Commission blocked the proposed merger of Alstom and Siemens. And we now have both an EU foreign subsidies regulation that provides extra scrutiny on transactions involving foreign financial contributions. And there now is a process to potentially revise merger guidelines with maybe some focus on creating more space to facilitate European champions. That's still to be seen. We've also, over the past decade or so, seen a significant increase in labor market antitrust cases, particularly at the national level, right? Where a lot of sort of the new approaches that you hear Lina Khan talk about, they're actually happening in some ways more in the EU, thinking about the various ways that non-poach agreements, wage fixing agreements, and information sharing cases can undermine labor market power as well as and also decrease wages. If we look at enforcement, we can see that there has been an increase in investigations of abuse of dominance cases, both at the national level and at the commission, right? A fairly significant increase since 2023. Obviously, enforcement decisions take a while to finalize. I can't quite understand how to read what's happening on the merger front. If anyone has any suggestions, it seems to be that more phase 2 cases are being withdrawn, right? I don't know if those are foreign companies. I want to look at the data, but something seems to have changed, right? This is some data that was put together by a law firm. And then all of us know about how many American companies have been fined or investigated by the European Commission. In fact, 9 of the 10 largest fines in the history of EU competition law for abuse of dominance have been tech firms. That I do not think is coincidental, but I'm curious to hear what the rest of you think. And we also see intensified merger scrutiny, particularly when it comes to mergers that involve different aspects of dominance. At the same time, you could argue there's continuity in EU law, right? If you look at, let's say, the proportion of total cases by the Commission, it hasn't actually shifted that much since even the 80s or 90s, right? We still see around a quarter, 20%, 25% of cases are dominance. We still see a significant number of vertical cases that has marginally decreased. And we still essentially have independent national regulators for the most part, at least formally speaking, and the European Commission calling the shots on which cases are investigated, right? In the UK, everyone is very upset about the recent political interventions, but that does seem to still be exceptional. I haven't found any other evidence of that happening, though I'm curious if other people know about it. And then, this is still a highly jurisprudentialized area, right? This is still something where I don't know of any European Court of Justice precedents that have been overturned, right? It seems like there's still some degree of consistency and continuity. Of course, it will evolve. I'm not arguing for a static role of the courts, but it does seem like this policy area is not about to be thrown completely out of the technocratic and jurisprudentialized institutional spaces that it has long resided in. So I guess the question for all of you is, what do we think? Should we conceive of politicization in this way? Does it make sense to be looking at party manifesto data? What other kinds of measures might we look at? I developed this diagram with some colleagues actually at Utrecht, Baskram Balasingam and Zlatina Georgieva, where we kind of think about maybe different cycles of antitrust on this pendulum of low politicization or low political salience to high political salience. Does that make sense to those of you who looked at competition law? Do we see something like a cycle over periods of time, or would you say in the EU context this is relatively new? Maybe this is like the first time we've seen a kind of politicization at this level of competition concerns. And then finally, how should we normatively understand politicization, right? My personal view, having not fully thought about it, is that repoliticization might be beneficial to democracy if it remains embedded in rule of law and democratic norms, right? It is one way where certain concerns that maybe were excluded can be brought into the process, right? Maybe we weren't thinking about all of the right questions when it came to market power, right? And maybe now we can expand that. Maybe we weren't thinking about labor and now we can think about it. But I do think it, of course, can be harmful if it just becomes a way for individual politicians to instrumentalize the state to go after political opponents, right? If it is not embedded in rule of law norms. And I do think, of course, this can erode the credibility of regulation. So I'd be curious to know how all of you would conceive of this from a normative perspective. Thank you very much.
Thank you. This was extremely rich, and now this gives us the difficult task of holding our questions until we have listened to everyone, because I sort of have the feeling that each and every slide could be discussed for quite some time. But we move on now to Anna's presentation. So will help us with your slides.
Kati, can you?
Oh, okay.
When I start,
I have
don't start yet.
Deep trust in the speakers that they. Yeah, now? Yep.
So thank you very much, Cseres, because I'm building upon everything you said. Saves me time. I'm going to talk about the question whether we should now limit corporate power in the companies because of their impact on democratic structures. It's a new question for me, though I've been working on corporate power and democracy for a long time. And the answer is going to be yes. So my main issue is, should there be limits to the power of big tech companies? Because it's not only power in the market, but power that stretches way beyond. And then I obtained an ERC starting grant, which was wonderful. It gave me 5-6 years of talking about one thing, this question. We broke it down in 2 questions. Big tech companies have far-reaching power beyond the market. What kind of power is that? And then also, how should competition respond? Should we stick with trying to fine for infringements of abuse of dominant position, just finding the abuse and never really worry about the power itself? Or should we now also move to attack the power? Limits the power itself. So that's the question. And today's topic relating to democracy and democratic structures. Well, some of the examples Cseres already gave, but we are worried, or what we're seeing is interfacing between political power and corporate power. The tech bros, you had a different picture. One Elon Musk with Donald Trump, of course. There's interference with elections. For example, in Moldova, very recently, Moldova voted pro-European Union, but could have easily swung the other way. There's direct voting influencing, and perhaps, but we're still not completely sure what happened in the Brexit referendum, whether or not it was political micro-targeting that actually swayed the population into voting for Brexit. But that there was political micro-targeting going on, so individual targeting of individual voters to vote A or B was happening. We just don't really know actual causal relation, or the effect was on the outcome of the votes. This has been happening for 10 years, something like this. People have been worried about this for a long time, not just me, many other people. But recently, the AI developments now increase the likelihood of big tech companies having an impact on democratic structures and the political process, because also AI is pretty much in the hands of the big technology companies. So the AI capabilities, the data capabilities, the developments, the investments in AI. It seemed like OpenAI was, anybody know? You all know what OpenAI is. Wonderful, great foundation, a non-for-profit foundation. It's now moving to a for-profit company, pretty much with all that. So it's strengthening the already powerful positions of the big tech companies. And if everybody agrees that AI is the new systems technology, like fire, electricity, computing power, now AI, this will change the way, well, pretty much everything, our economic structures, but also our society. So this increases the power of big tech companies, not just in the market, but also outside the market. Now, we do have competition law, and competition law is concerned generally, this is also what Cseres was saying, power as, well, you weren't literally saying this, but it builds on your presentation. Power is market power, and I'm simplifying here, and harms that we want to counter with competition law and market harm, mostly focusing on consumer welfare. So price increases, lowering quality, lowering innovation. And we have cartels, abuse of dominance, merger control, of course, but we're not really policing against power itself. And we focus on, we need power to use the hammer of competition law to smash the harms, but we don't use the hammer to smash the power itself. And the harms are only market harms. So we have a hammer, but it doesn't fit problems. If you agree with my analysis that we have a problem with big tech power is more than market power, it also feeds into democratic structures and political processes, and we have this big hammer, should we not make it fit? So what do we need? Academics then say, we need a new concept. We need to know what kind of power this is. This is my modern bigness group. Somebody made the logo. Actually, the husband of one of my PhD candidates made the logo. So we try to answer the question, what kind of power is this? And I'm going to go through this a bit by bit, but it's fairly self-explanatory once you understand it. So we said this is different kind of power because the power, the foundations of this power is now in the new economy, the networked economy, the platform ecosystem. about system economy, where we're all locked in data loops, network effects, stuff like that, but also foundations of power that the big tech companies very much, they very much determine innovation paths. Because they buy up innovation, they shape innovation, they have the capabilities in AI innovation, which also sort of increases their foundations. It's very difficult to dislodge them from their foundations in that sense. Then we say, okay, there's different dimensions to power. And here I only quote one person. She's a woman, Doris Fuchs. You should always be mindful. I am going to say this, Kati. Women get cited much less in presentations and in articles than men. Try to make it 50-50, or try to at least cite the women who do publish on the topic you're publishing about. Woman, Doris Fuchs, she's wonderful. She's not talking about competition law. She came up with this idea. Listen, if you have a corporate power in relation to politics, there's really 3 dimensions to it. You can have an instrumental power. I'm telling Jan what to do. It's very instrumental, what I say, or there's also structural power, like women get cited less. That's the structure of academic discourse, and it feeds, it's a kind of power in the structures of the system itself. Market structures, of course, are a structure as well. And then there's discursive power, which is power over the narrative. What are we talking about? What do we think is relevant? How do we talk about it? So it's not just who talks and using that power instrumentally, it's also the structures on how we talk about stuff, how we come to decision making, and then what we talk about. And then we added, so competition law is only about economics and even smaller markets in the market domain. But if you look at this kind of power, and Fuchs says this, but she doesn't talk about big tech companies specifically. She says, she talks mostly about the effect on the political domain. So what is the effect of corporate lobbying power, which can be instrumental, structural, discursive in the political domain? So we added political domain, social domain, economic domain, personal domain. I'm going to skip social and personal for this presentation because we're talking about the political domain. And the idea is that with this concept, you create a language for competition authorities and for competition people to talk about what they see happening in real life. If you don't have the words, this is very academic again, but if you don't have the words, if you don't have the labels, then it's very difficult to grasp what is happening. Then competition authorities can say, yeah, no, but we're talking about consumer welfare. We are now saying, no, listen, this is all interconnected. So you can have big tech companies with their foundation in market power, which is a competition law thingy, using discursive power, power over the narrative, to influence politics. So once you have this language and be free to create your own, nobody needs to use weakness specifically, but we wanted to show that there's a way of thinking of the interconnectedness of the power of the companies that brings it into the realm of competition law. And then you can also do something about the harms that end up in the political field. So, for example, political micro-targeting. Yesterday, Victoria Moderator was here. Was one of my PhD candidates. She wrote her dissertation on political micro-targeting as a competition harm by using the infrastructures of big tech companies and how that links to ultimately the power over these structures. There's also discursive power, shifting the Overton window is really what is normal in policies. It's a bit what you were talking about, Chase. It sort of connects to that. But I'm very worried at the moment also about big tech going into the public sector, though. And the public sector, you could say, is well, I'm not sure if you call it political, but at least is part of modern Western democracies where the government has a big stake in creating public services for citizens. And what you see now happening is that big tech companies are also moving into the public sector. And our language of modern bigness gives you a tool to at least see what is happening there and then decide whether you can use the hammer of competition law. Now, very practically, quite recently, and Kati apparently is writing a note on the decision of the Dutch Competition Authority in a merger between the two Dutch language news outlets, BEUC and ACELG. They merged, and ACM asked us to provide an expert opinion on whether or not opinion power, because the media authority had pointed out that this merger would lead to opinion power in the Dutch media market. And the competition authority asked, well, okay, but what can we do with opinion power in a competition law analysis? Because opinion power is not about consumer welfare, it's not about prices, it's not about the consumer at all, really. Opinion power in quality media markets means us as citizens, impacting us as citizens, not so much as consumers. So we provided an opinion saying, well, okay, this merger will then lead to less media plurality, which has an impact on not just the citizen, not just the consumer, but the consumer citizen. In this digital age and with AI more and more in play, we are not just a consumer anymore. We're not just a citizen. You're browsing your TikToks, you see something political, you're suddenly a citizen, you're seeing an advertisement of a nice product you want to buy, you're a consumer. It's behind the scenes for the TikTok algorithm, there's no distinction between those two. So we're saying more generally, the consumer and the citizen in this digital age, you cannot really distinguish them anymore, which also means they come into play, or they come into the purview of competition law remedies. So this merger would lead to less media. We did not say that it would lead, but if it leads to less media plurality, we did actual analysis, then it will have an impact on the consumer citizen, a loss of quality journalism, and less diverse public sphere. Here we have Habermas and stuff. So, and that is a relevant competition law concern because of the linked foundations of power. Now, the thingy here is very interesting because this is small fish. DPG and RTL might get a dominant position in the Dutch media ecosystem of quality journalism specifically, but they are not big techs. So we were also very careful to say you have to look at this in the bigger picture. And such a merger can also be a counterpower against the power, the narrative power, and the news power, the power over the public sphere of the big tech companies, algorithm. So what the ACM did was not prohibit it, but have loads and loads of remedies in place to make sure that the different titles would remain separate, editorially separate. So we were. So that brings me back to my question. I'm almost done, Kati. Yes. Should there be limits to corporate power? This is a normative question. So we have a little normative framework, which I'm really, really summarizing here in an open society based on democracy and rule of law. I think the answer should be yes. And the reasoning is we have this hammer, and she showed you the graph, so many high fines, right? And nothing happens with the powerful positions themselves. So at some point you need to change the shape of your hammer. You need to broaden the wooden block, not just markets, but also democratic structures, but you also need a different hammer, not just policing the effects, but maybe thinking about limiting power itself. Now that's opens a can of worms because how, what, who,
What do you mean?
Well, for example, but this is the debate already. I always ask questions. This is new for me. This is the first time I'm proposing it. Well, actually, on Tuesday, I proposed this for the first time. So I've been working on this for 6 years. I kept saying, no, we cannot break up the big tech companies. There is no legal basis in it in the European system. It's very difficult, network effect. A new Facebook will just pop up. So why would you break it up? I've moved. I think the danger, especially because of the AI revolution, is now becoming increasingly present, salient, whatever word you want to use. What you could do is section off parts. So for example, if big tech companies are entering healthcare, which they are, which is a public service in most European countries, you have to section it off. You either split it off, you spin it off in a new company, which is subject to all the regulatory frameworks that we have for health services, and you can do the same for, I don't know, creating their own coins. The Libra coin never amounted to anything. So that's one thing you could do.
Yes.
And that was my final slide.
Yeah, thank you very much.
You're not on the
Change the
camera.
slide, right?
Oh, yes, Alicia.
I think I can do it, no worries. I told you did it before.
If you move to that side, then people online can see you.
Okay,
That's why they.
I can.
No, but if you sit, it's good, right?
It's fine.
If you sit, you can stay there.
Okay.
Is that correct?
I can go if you want, if it's better, same for me. I will just go with all my tissues, but. So, hi everyone, I don't know if this will work.
Off, you
It's
can-
off. Oh, okay,
just-
okay, perfect. Okay, I will try to, it's always complicated to arrive like third or fourth to a talk because a lot of things were said and a lot of things were said sometimes that I can build on and sometimes things that I would not disagree, but put a different emphasis on.
Yes.
So just to keep it short, I will go straight to my presentation and then feel free to ask, okay, does this make sense to what was presented before? I would totally argue that there is a different type of power, of economic power. I would also argue that competition authorities have, for historical reasons, many reasons, neoliberalism, the Chicago schools, and many things, have become very narrow-minded when it comes to looking at economic power, and they have turned economic power into synonymous with a specific type of market power. And even for neoclassical economists, there were two guys that are like associated with neoclassical economics. One is a guy that was called Alfred Marshall, and for him, you should look at the markets as detached from each other. So I think that is called partial equilibrium, whereas there was another guy, also mainstream economist, that was called Leon Baldrat, and for him, it made no sense to look at one market at a time because all the markets were interconnected. And this guy was writing more or less at the same time that Marx was writing Das Kapital. So it's not a globalization guy. But already back then, he knew that all the markets were interconnected. And it made no sense to try to arrive at a sort of partial analysis of one market at a time because you would be missing how what was going on in one market was at the same time affecting all the others. So imagine over 150 years after that, and with globalization and so many changes, and also with technological changes that have also contributed to deepen the interconnections between markets, and not only markets, how narrow-minded competition authorities have become. So to go down, and because I'm an economist, I can say this because I have this privilege of not being like directly part of the team. So I want to start directly by looking at the problem that we are facing. And the problem is not just corporate power, it's the entanglement between corporate and political power. One that is not new, but that certainly today has come completely to the fore with the relationship between Donald Trump and big tech companies. So basically, my main argument today would be that the world powers are governing beyond ownership. And the world powers today are not simply the US and China as economies, as their states exercising power in representation of the country, but this complex entanglement between US and Chinese governments respectively, if you want, and their big tech companies. For Europe, for many, many reasons that we can discuss later on, what matters the most is what's going on with the US. Although Europe in other parts of its economy, like automobile industry, is very much concerned with China more than the US. But in this discussion, it's more about the relationship with the US corporate powers and political powers. And here is where I will introduce you to how I see network power, economic network power being exercised. A way of exercising power that also goes beyond the network connection of markets. And just to give you more emphasis on why this is needed, is also because this type of exercise of power is directly impacting not only on peripheral countries such as Malaysia and Cambodia, where their trade agreements with the US are affected precisely by what Trump was saying there, which is basically in the trade agreements, they are including that these countries cannot levy any tax on digital companies, cannot regulate the companies, and so on and so forth. And one would say, okay, this is more of the same, dominant governments, dominant economies, exercising power on peripheral ones, but also this way of exercising power has become so strong that directly and openly impacts on EU regulations. So how is it that these companies became so powerful? And the power is way beyond, and this is small on purpose. You can then look it up if you want and do your own analysis, and I will explain simply what this is. But for the sake of being very short in my presentation, I don't want to go into the methodological details. But the way in which these companies exercise power beyond ownership is different from what one historically would have assumed when thinking of big companies. One thinks of a big company as a company that simply becomes bigger and bigger by hiring more people, investing more in tangible or intangible capital in-house, so having larger R&D laboratories, larger offices, all the talent, and today one would say also concentrating all the data. And this is true for big tech companies, but they also control beyond ownership. And a way to see it is by looking at how they were placed, or where they were placed in the AI scientific field, in the frontier AI scientific field. And this is what I'm portraying here. By looking at the top 14 AI conferences in the world between 2018 and 2020, one can see in the network of co-authorships, so who was presenting papers with whom. Let's say we co-author a paper, then we go present it at a conference, then our two institutions will be linked. When we look at which were the institutions presenting at these conferences and what the links were, what the strongest links were, we end up with a map that showcases Microsoft and Google at the center of the map. This means that these companies have an extraordinary capacity to influence not only their direct co-authors, but also the co-authors of their co-authors and the co-authors of their co-authors of their co-authors, and so on and so forth. So basically, the AI research agenda is what they want. And because are the most important AI conferences, this means that everywhere in the world will be looking at what's going on here when deciding what they are going to do research on. One could simply say, okay, but they are super cool. It's a conference. They go, they present their research, they are sharing open knowledge. But in fact, they don't go, of course, and share the coding of the models. They just go and set a research agenda. They say, these are the type of models that we're working on. These are the type of results that we're getting. These are the type of applications for healthcare, for government, for defense, for education, and so on and so forth. So they influence the research agenda without really disclosing the content of their models, the code of the models, the data that they use for training, and so on and so forth. And a way also to compare how they capture knowledge, and one of the ways in which they are capable of exercising what I would describe as a predatory behavior, where they are working together, collaborating, developing research with thousands of organizations, but then profiting mostly by themselves, is to compare the share of co-author publications with the share of co-owned patents. For Microsoft, for instance, between 2012 and 2021, almost 9 out of 10 scientific publications that had at least one person coming from Microsoft also had at least one person coming from a different organization. Universities, public research organizations, other big tech companies, startup companies, and so on. So 9 out of 10. And then we go and we compare the share of co-owned patents in the same period, only 1%. This means that only in 1 out of 100 patents, they are sharing the property of the patent with someone that is not Microsoft. So this is clearly for me an example of knowledge predation. But it's not just a way of capturing what then ends up being a key intangible that one could still say, okay, this is happening in the public sphere, the public knowledge domain, but at the same time, we've seen the emergence of a lot of startup companies. Yes, thousands actually. But then when we go and see who's putting the money for these startup companies to exist, we find again big tech companies. And here you have the list of the top investors in AI startups by February 2024. And you can see clearly on top Google, then you have Microsoft and so on. So the case of OpenAI and Microsoft is not an outlier. The relationship between the two companies is not an extraordinary case. It's simply part of a very established dynamic in which leading corporations exercise their power on smaller ones by pouring money into these new companies. And why are they doing this? Why are they doing this instead of one, acquiring the companies, and two, why are they doing this at such a widespread level? First of all, of course, you may be thinking, okay, if you don't acquire, you're not scrutinized by competition authorities. Yes, but the true reason goes way beyond, because when you're not acquiring, you're diminishing the risk. Of course you invest, but the investment is not the same thing as the acquisition in terms of economic and also technological risks. And the gains are the same. Because when they invest in these companies, they get privileged access to the knowledge, to the technology that the startups are developing. And they can also steer the development of the technology. So basically, they take the most from the startup without incurring in the potential drawbacks or liabilities. And this is something that is not only happening at the level of AI startups. You can see here on Financial Times not so long ago how Microsoft is investing in also the companies that are part of what could be described as the data center value chain. And it's also happening inside the core. The result of this structure, where we have these strong leaders, I would describe it as a sort of established core with a turbulent periphery. So we have the same companies at the core, and then a lot of entry and exit at the level of the periphery. So from a competition perspective, it seems that this is a very dynamic market, but actually this dynamism stays only in the periphery and is put at the service of reinforcing the hierarchy of the core. And the core also reinforces itself because they need each other. And this is also something different because even companies coming from, in principle, different markets and sectors are investing in each other and do strategic agreements with each other to reinforce their respective power. And you have there the example of NVIDIA investing money in and taking equity in Intel. And behind all this, where I see the most problematic segment of this very complex network, it's the public cloud. And the public cloud is not just infrastructure as a service, actually. Everybody at this point knows that in the cloud, you can use GPUs as a service to train your models. We store our pictures, and the same with companies and all types of organizations, including also governments. But the cloud is also a supermarket. The cloud is a supermarket of digital technologies. Every digital technology can be purchased as a service, can be rented as a service on the cloud. And as an example, you have there Amazon Web Services with over 30,000 services being offered in April. And now I think there are about 35,000 services. And why is this so important? Because actually, for us looking at corporate power dynamics, the cloud is not only a marketplace. The cloud is at the same time the place where digital technologies are produced, exchanged, and consumed. And this doesn't happen as a linear process. Let's say I'm manufacturing the smartphone, and well, I have a Pixel, but let's say it was an iPhone, and the assembly part takes place in Foxconn in China, and then the iPhone is sold, I don't know, in London where I live, and then I consume it in my house here with you. These are 3 different places with its own norms and regulations, and at the same time, there is a linearity in the process. In the cloud, everything is shuffled, everything is mixed, because when you are developing a digital service, you're at the same time consuming other services in order to develop your own service. And every time someone purchases your service, you will be at the same time calling the other services that were used to produce your own service. So everything gets so entangled that then it becomes impossible to live. And this is where the locking has, I was going to click with my phone, this is where the locking has no parallel. Yes. And in this story, I see generative AI as a sort of Trojan horse, because everyone, from small organizations to large ones to governments, are feeling this need, this eagerness to be part of the AI boom. And to do so, they are migrating to the cloud, because even Meta's Llama and DeepSeek models are offered as a service on the cloud. So if you want to adopt AI, if you want to develop services based on AI models and then sell them, you need to be on the cloud. So in the end of the day, it doesn't matter if all the promises of AI deliver. I don't think AI will cure cancer, to be fully honest. But even if it did, it doesn't matter. And if it doesn't matter. Because what matters is that by the time we realize that these promises, some of them may deliver and some will not, everybody will already be inside the cloud and it will be impossible to leave. And when I say everybody, it is particularly problematic that this dependency is making governments more dependent. The same governments that then need to go and regulate these companies. Will you be able to regulate a company that if you go very hard against it, will simply switch off your capacity to work? And this is where the things get even more complicated, because this was already happening before Trump. But Trump has not only revoked Biden's AI executive order, which was in the end simply regulating AI uses. Trump has also introduced, among other things, the AI action plan. And the action plan is not only about connecting AI with the cloud. When you read it, every time they are saying that they want more AI, but more AI is also more cloud. They are increasing their own government's dependence on these companies, but they are also pushing allies to adopt US AI and cloud. And again, this is not new. The US government has been instrumental, has been key for the emergence of these companies and also for the business of these companies around the world. But the fact that this document, official document, it's saying it very openly, that if you still want to remain an ally to the US government, you need to adopt the US AI and cloud, given what I said before, should be a concern of European regulators. And instead of simplification, they should be doubling their efforts to regulate these companies. So what has changed? Why is it that now it's so problematic? And of course, one of the problematic angles is the AI boom, for the reasons that I was explaining before, because everybody wants to be on the cloud, everybody wants to adopt their technologies and so on. But I also think we are witnessing, and this is connected to the fact that the far right is no longer at the fringe of our society, but at the center of our society, a lot more legitimacy. You may remember that in 2014, there was this scandal, actually, with Project Maven. Google, working for the Pentagon, and Google employees came out and said, we don't want Google to continue working for the Pentagon. And Google, at least allegedly, stopped that contract. We fast forward to today, and Google publishes in its blog a celebratory message saying that they were awarded a $200 million contract with the Department of Defense. So this really changes the way in which our society at the same time is accepting this type of relationships. Before they had to hide it, now they are celebrating that. And of course, if it comes to celebration, the fact that Elon Musk was part of the US government gives us even more reasons to believe that this, in the midst of this geopolitical turmoil and the fact that the far right is becoming more and more relevant globally, the legitimacy not only of their discourses, but also of these companies is expanding. At the same time, they have been receiving open government support. And I think that we should pay a lot of attention to the fact that it was not just NVIDIA investing equity in Intel. It was also the US government. And it was not a subsidy, it was not a grant, it was equity. So the US government is also trying to rebalance its power within this ruling coalition. It's also trying to say, hey, I shouldn't become also dependent on these companies. And a way to do it is by positioning itself also as if it were a corporate player. And there were a few anti-competitive fines also that the companies accepted that they were paying. There is one on Amazon. Yeah, I was. This is the last slide. Yes, you're right. There was one on YouTube and another one on Amazon Prime. And of course, the companies are at the same time trying to take some distance from the US government. And this headline, it's amazing on that regard. Microsoft data sovereignty, now with extra sovereignty. And I can come back to this and why the US Cloud Act is problematic, but the fact that these companies are trying to sell governments around the world sovereignty as a service is extremely problematic. And all in all, besides all this back and forth within the coalition, I think that anyway, we need to accept that they are strengthening their authoritarian core. So just as my final slide, I think that governments around the world, and Europe in particular, are facing a trilemma. One is that they want sovereignty, and they still need to figure out what sovereignty means, and I can tell you what it means for me and what it shouldn't mean, but we leave that for the Q&A. But they also want growth. And there is an AI exaggerated growth promise. And this is problematic because this is one of the key reasons why they are accepting these companies and they are also adopting themselves their technologies. And the third part, and this is why it's a trilemma, is ecological crisis. So a way out, I think that there needs to be, governments need to make bold choices. And also I think we need ecosystemic regulation. It's not just about competition policy, but at the same time, it cannot be done without competition policy. And we need that every single dimension within governments need to be put at the service of thinking about creating an alternative ecosystem that really delivers to the people and also remains within planetary boundaries. Thank you.
Yes, thank you very much. You came third or fourth as a speaker, and I listened to you several times, but every time I find it very original and also very alarming what you are telling us. So now we move to our last speakers. I already have questions, so
strict with time, or there is no time.
How much time do we have?
We only have around half an hour, so 10 minutes max. I'll send Kati a sign.
Yeah, because I already have one question from online, and I'm sure we will also have, but please go ahead.
Okay. All right. Well, if it was difficult to go third, it's even tougher to go fourth, because I've got questions also and comments to what has been said already. Thank you very much for inviting BEUC to this conference. It's great to be here. So for those of you who don't know BEUC, we are the European Association of consumer groups from across Europe. So we have 45 independent national consumer groups as part of our membership. Just to be clear, we are not authorities though. So if you know Consumentenbond, for example, in the Netherlands, they are our members, which in the UK, UFC Que Choisir in France. And we're the largest European network of consumer groups in Europe. So that's 45 independent national consumer groups in 32 European countries. Now, what we do is advocacy in Brussels, advocacy on EU legislation, trying to defend the consumer interest in EU laws. I work specifically in digital competition issues, so I'm part of the competition team. Much of the panel so far has focused on how we need to broaden competition policy to tackle corporate power. I would tend to agree, but I'm going to give you a bit of a snapshot into how a very specific set of rules are faring at the moment in Brussels, the Digital Markets Act, how that fits into the broader landscape today of corporate power, geopolitics, and EU industrial policy. How many of you are familiar with the Digital Markets Act? Do you know quite a lot about it? Or do some of you just know a little bit, might know the name, but not know what it's actually specifically trying to tackle?
People are familiar.
Okay, people are familiar. Very good. All right. So quick summary, it's a set of obligations and prohibitions for 7 gatekeepers. At the moment, 7 might be broadened at some point. So it's a very targeted piece of legislation. I would say that in March 2024, when it entered into application, it got off to a flying start. The Commission was very keen on opening investigations, which showed that there was a real will to enforce this legislation. And that was very positive. So 5 investigations were opened immediately. In this time, we've already seen some improvements. So the Commission has adopted this approach of a mixed approach of regulatory dialogue, which is the carrot, and a stick, which are fines for the companies when they do not comply. And I think that that mix is important, and it's had its uses, because we already have some consumer benefits which are starting to show. Take, for example, the browser choice screen. For those of you on iOS, you now have a pretty good browser choice screen, which is neutral and allows you to choose the browser of your choice on your device. You also have new wallet solutions in certain countries, also on iOS. Take Germany or the Scandinavian countries. In the past, you had to go through Apple Pay if you had an iOS device. That is no longer the case in certain European countries. Things are being opened up to more competition. No more tying of Gmail to your Google account. Might sound small, but that's a positive, and it's something that's come out really because of the Digital Markets Act. But all is not rosy, unfortunately. And what I work on specifically is enforcement and compliance by the gatekeepers with a DMA. And I'm afraid to say that the scale of non-compliance is still pretty staggering. Now, what the gatekeepers are doing, I think they're being obviously quite clever. They're not sort of saying, we're not doing anything. They are putting together compliance solutions, but some of them are only semi-compliant, and I think they probably know that. We have put together 17 different legal submissions into the Commission to tell the Commission where we think the gatekeepers are not complying. For example, the user flow for downloading an alternative app store. I really do encourage you to try and do it yourselves on iOS or on Android. It's not easy, it's not neutral, and the gatekeepers know that. They are making it as difficult as possible within the limits of the law, of course. And these are the kinds of things that are being discussed in Brussels. Self-preferencing by Google. Go onto Google search and you will see that there is still self-preferencing going on. Now that's a very complicated debate. I would say it's much more complicated than the debate on installing an alternative app store, but there is still non-compliance by alphabet. Try closing down your Facebook account. I did it last week. It's an absolute nightmare. And that is also banned under the DMA. You have to make it as easy to open the account as to close it. And that's not the case today. So another very concrete example of how the gatekeepers are still making things difficult for consumers. Now, where do we stand on non-compliance? There are still only 2 non-compliance decisions that have come out from the Commission, and that was in April this year. Is that enough? Clearly not. There are many new investigations which need to be opened as far as we're concerned. It is clear that the Commission has a resources problem. It's not exactly clear how many people they have working on the DMA, and they have some very good people that I'm in regular touch with. But is it enough to tackle all the provisions and all the gatekeeper solutions that are being put out there? Almost certainly not. So they've had to prioritize which cases they open and which ones they're going to open later. The downside of that is that gatekeepers are still getting away with breaking the law, as they have done with the GDPR, as they are doing also with the Digital Services Act and with competition law. And it's clear that for some of these gatekeepers, I'm not going to say for all of them, the strategy is delay, delay, delay. Time is on their side. And appeal again, and appeal. Delay, 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 appeal, appeal. Apple is going to die on that hill, defending its ability to extract rent from app developers, the so-called steering rules. They've made that very clear. They're not going to give in on this. They have already appealed. I can already tell you that we are intervening to support the Commission on this case before the General Court in Luxembourg. And Meta has made it very clear that they are not going to make it easy for people to choose a less personalized ads option, which they have to provide under the DMA. That has also been appealed. It's going before the General Court in Luxembourg, and we, as BEUC, will also intervene as a third party in that case as well to defend the consumer interest and support the Commission. So a legitimate question is, given this kind of where we stand on the DMA, are we better off with the DMA than without it? I would say undoubtedly yes. Proving dominance and abuse is not necessary, just like it is with traditional competition cases. So we are definitely better off. And what is forbidden is relatively clear, despite what some of the gatekeepers say that, oh, we need guidance because this isn't clear or that isn't clear. I would say that some of these cases, at least, what part of free of charge do you not understand? Now, where does this sit in the kind of overall context of geopolitics, digital sovereignty, industrial policy? Well, unfortunately, two major things have happened in 2024, which I'm sure you're all very familiar with. The first one is the European elections. We have now the most right-wing European Parliament ever, which reflects the fact that we have so many right-wing governments across Europe. We also had the Draghi report, the famous Draghi report, which calls for simplification and greater European competitiveness of companies. And that's become the order of the day in Brussels. So I think we've seen a clear change in Brussels when it comes to the priorities of the European institutions. Clearly, in the next 4 years, we're going to have less digital market regulation. That's absolutely clear. The only real exception will be the Digital Fairness Act. There is a question, though, about how will the current rules be enforced. I would say that it's still looking better for the Digital Markets Act than it is for the Digital Services Act, or certainly for the AI Act. But the second big issue which happened in 2024, I hope I'm still okay in terms of time, is big tech got a trump card. And the front rows at the inauguration, or second or third rows, whatever it was, that's not a coincidence. And so this is where I'm really joining the two speakers by either side of me. We do have clearly a problem when it comes to corporate power. I would argue that a lot of the big tech speaking points have now become White House speaking points. And unfortunately, the European response has not been as loud as it should have been or could have been. This Monday, we had the visit of Howard Lutnick, who essentially said that Europeans need to go soft on their rules if they do not want to be hit with tariffs, for example, on steel. And the result of that was, within hours, a German minister came out and said, well, maybe we should go easy on the big tech rules. And that is a real problem going forward, because what it means is that what big tech would like and what the American administration would like is having some effect. I'm not going to say that it's a success, because I think clearly the response that we've had this morning, actually, from Teresa Ribera, the European Commission, has been very good, actually. She's called it blackmail. And it's about time that the European leaders say what it really is. But it is an entangling of our rules with deregulation and trade policy, and that is very worrying. Suddenly, fines for gatekeepers are rhyming with tariffs on European goods being exported, and that is a real problem. Now, what does this mean for the Digital Markets Act and competition policy more broadly? Well, there are some good things that are happening, and I think one thing that we can be very happy with is that competition authorities across Europe are getting involved and trying to do their bit on the DMA. And they might be using competition law to do it, but I think the Bundeskartellamt opening of an investigation against Amazon's pricing controls is extremely positive. So that was back in June this year. The Italian AGCM threat of an injunction now against Meta for the use of Meta AI in WhatsApp, I think, is a very positive sign as well. And I think that that's a good thing, because it's keeping pressure on the Commission, but also on big tech to say you're not going to get away with these things. Another positive is that this regulation is very targeted, and it's only hitting 10 So it's not something that is applying across the board to all European companies. So I think this is where the DMA, the Digital Markets Act, I think has a leg up on, for example, the Digital Services Act, which is much, much broader. And most companies, European or from America, stand to gain from the DMA. And I think that's a real positive. So one thing that I will come back to is I think, and I think this goes back to something that you said, are American companies being targeted? I think the correct question, I would argue, is actually who owns the tech stack today? And they happen to be American, but I think that is more coincidence than a question of nationality. And I think we need to be really clear on this. A lot of the challenger companies who stand to gain from the DMA are actually American, I'm afraid to say it, not European. And so that's another thing. The bad point, and I will finish with that, is that the gatekeepers have gotten very loud this year since Trump was elected. They have become very, very loud. And they are coming out with surveys every few weeks now, saying how consumers absolutely hate the Digital Markets Act, even though most consumers have no idea what the Digital Markets Act is about. They're saying that the Digital Markets Act doesn't benefit companies. Well, perhaps because you're not properly complying with the law, could be part of the answer. And Apple has gone so far as to say that the DMA should be repealed. It won't be. I think that's pretty clear. The problem that we have as a consumer organization in Brussels, though, is that we and others can never be as loud as big tech can be. Their pockets are so deep, and the way they are controlling the narrative in Brussels is phenomenal. They use astroturfing organizations, fake think tanks, coming out with papers every week. And the amount of money they can throw at lawyers and at the media is phenomenal. And that is a problem where we never get any semblance of equality in the public debate. Now, I think I probably have to finish here.
Please.
But I'll end on a positive because I am an optimist. And I think it's very, very important that we all speak up about these rules, why we need these rules, why we need more competition. And BEUC will continue to be a strong voice for consumers in Brussels. And it's important that also to note that there are lots of other organizations and companies fighting for the DMA to be properly complied with. Thank you.